Hi, and welcome to Healthcare Headlines. I'm Amber Walsh, Chair of the McGuireWoods Healthcare Department. Today, I am pleased to be joined by my partner at McGuireWoods, Sam Tarry. Sam is an expert at consumer and product litigation. Among other accolades, he is the recent past chair of our firm's consumer and product litigation department. That group is phenomenally helpful to our healthcare clients and investor clients in helping to assess a broad range of risk and liability issues, risk management, and kind of looking ahead towards the future at what might be coming down the pike in the healthcare industry and certain products and services liability issues. So very pleased to have Sam join us today. He is a public health liability expert, and among other things in this conversation, he's going to talk to us a little bit about the changing landscape of liability issues in public health. So, Sam, welcome, and thanks for joining.
Thanks for having me. It's fun to be here.
So, Sam, I know that throughout your career, you have seen major shifts in the interplay of risk bearing, risk allocation, risk management techniques as between two major stakeholders in the healthcare industry. You've got the providers on one hand, you've got the manufacturers. Can you share with us your views on those shifts, that evolution?
Well, not surprisingly, there have been a lot of shifts. There are two major trends that I think drive a lot of the secondary and tertiary trends. Number one is tort reform, and number two is the assetization of litigation. And maybe I'll start in reverse order. So litigation funding in the United States is about 15 years old now, and there traditionally were two classes. Anywhere you have a lawsuit and a plaintiff and a small attorney suing a provider or a manufacturer, you have typically had a market that you could go to get a loan to front the litigation, $500, $1,000, $1,500. That trend hasn't really created much ripple effect. What has created a lot of unintended consequences and has changed the dynamics of risk management for a lot of medical providers is the larger, more mass tort-based litigation funding. Bloomberg last year estimated that there is approximately $85 billion sitting in the market in funds ready to invest in plaintiffs' litigation. Now, a lot of that's intellectual property, it's commercial, it's not all personal injury, but certainly a lot of it does get directed at the high-profile cases that we can all recount or Google, from hip replacements to pharmaceutical litigation. Of that 85 million, it is estimated that somewhere in the single digits are actively invested. So a lot of it's sitting on the sidelines. But what that does is it drives, obviously, a lot of litigation that in the past would not have been brought. And even if it had been brought, would have been settled or settleable, if that's a word, that doesn't get resolved now without the acquiescence of the holders of those litigation assets. That's number one. Number two, and this is an unintended consequence of a good story, tort reform. So most of your audience who are in the healthcare field today enjoy a better landscape of liability protection than they would have 30, 40, 50 years ago, because virtually every state I'm aware of across the country has enacted in the past decades some form of a liability cap or a precursor or prerequisite to filing a medical malpractice case. You have to go present to a panel first before you're allowed to sue. Those are all great protections, and I think have been lauded across the political spectrum by and large. People appreciate that providers need that protection. People in rural areas need providers who can afford their malpractice coverage. That's been a good trend. The unintended consequence has been to redirect or misdirect the attention of plaintiffs' lawyers away from a hospital, away from a clinic, away from a provider to a deeper pocket co-defendant that doesn't have a cap, because there's a higher potential for recovery if you sue the medical device manufacturer, the vendor, the pharmaceutical company. So there's already a lot of money there. So the assetization of litigation generally has made it more big business, and the higher returns on capital are no longer found at the provider level. They're found at the manufacturer level.
That is really fascinating. And you used some words that I think are really interesting for those in my world, healthcare transaction attorney and healthcare private equity attorney. You refer to this uninvested pool into litigation funding. In our world, it's referred to as dry capital. It's uninvested dollars that may make a particular healthcare acquisition target that otherwise wouldn't be as attractive, but because you have all this uninvested capital, this dry powder, you have people making these investments and eager to push along acquisitions and maybe push along litigation in an analogy here that otherwise wouldn't. That's really interesting.
Right. And there's been a gap traditionally. So nobody knows how much dry capital is out there, and nobody knows what slice of that pie is really directed in the healthcare industry. But certainly, if there's $75 billion in dry capital, a significant portion of that is going to be directed toward healthcare providers or manufacturers. And the gap that I talked about between the large mass tort expenditures and investments and the just sort of one-off loaning of plaintiff money is being filled in recent years. There's an online fund that invests in large recovery single cases. So if you had a very bad outcome with a patient in your clinic that unfortunately catches the attention of a lawyer who has access to the online funding, there was a fund that raised about $100 million last year to target those types of cases. So the gap between the big and the small, that mid-market litigation funding gap, is being filled most recently.
So then shifting, so that's a little bit on trends, shifting to advice. What would be some do's and don'ts, as you might say, for healthcare providers and manufacturers in responding to an outbreak, a bad patient outcome before it results in a claim?
Right. And a lot of this will be common sense, but I guess 4 primary points. Number one, what you would do anyway, and that is do the best you can for your patient, while remembering that your patient's lawyer is not your patient. Once it becomes adversarial, you've got different obligations. Number 2, think big picture. It is natural to, in risk management, see what's immediately in front of us and want to end litigation, want to cut a single case off before it grows. That's natural, and I'll come back after the next 2 points. The best practice is to think long term and about the repercussions of what you do to resolve or to avoid a single case. But 2 other points, and again, these are common sense: good investigation and record preservation. So another trend in mass litigation certainly has been discovery gotcha, which is the sanctioning or the leveraging of discovery disputes against a provider, because none of us are perfect, and unless you're really adroit right away in reacting and saying we may have an obligation to preserve all of our documents here, if you're not perfect, sometimes that can result in leverage against you in the litigation that's frankly just as dangerous as the bad patient outcome, depending on the court you're in. So record preservation, and then thorough investigation, just figuring out, again, doing the best. These are not inconsistent. figuring out exactly what happened, and owning up and being above board and communicating to your patients truthfully to the extent you know what happened, and not hazarding guesses, not blaming others without being certain about that. So those are all common sense sort of things that you, even outside of litigation, you would hope are natural, but the threats of lawsuits create perverse incentives that make us not always follow those.
Sure. Good advice. So now I can't let you go without asking about the impact of COVID-19. And maybe a year from now on this video series, I won't be asking my colleagues and other guests about the impact, but I think we've all seen that COVID-19 has had such a broad array of impact, both permanent and temporary, on so many different issues. So I would love to hear from you on how COVID-19 impacted this liability and risk management discussion.
Amber, I think there's a good news and a bad news answer. The good news, there is real reason to be optimistic that we are going to now inherit and live in a better, safer, more hygienic world, which includes even our healthcare, or maybe especially our healthcare. Nosocomial infections have been the bane of hospitals and clinics for a long, long time. And the CDC has task force and the FDA has tried to help fight it. And it's just a lingering, difficult problem. I think that a lot of healthcare providers and clinics are going to get an assist from patients now, because we all know the importance of washing our hands. We know the importance of respiratory ailments and environments and the risks associated with that. Does that mean that everybody who comes into the doctor's office is going to wear a mask? No, but I think we're going to clean better. I think we're going to space better. And I just think we're going to take a lot more precautions that could put a real dent in hospital-acquired infections, nosocomial infections, and those sort of secondary bad outcomes that nobody wants their patients to get. That's the good news. The bad news, and this can be avoided too, but there's no denying the statistics. I think the CDC estimated that during the pandemic, about 40% of American adults skipped medical care. Right? People just didn't go to the people. We all were at home, and we viewed any amount of going out as a risk, and that certainly applied to patients. Depending on your discipline, those statistics may be widely different, but I think 12% of adults, according to the CDC, avoided urgent care. Almost a third avoided routine care. So what does that create? It creates a backlog that we are probably beginning to work through now as the world opens up and as healthcare begins to deal with that backlog of patients. So the risk is, and again, this is just basic human factors. The risk is we get in a hurry, right? When you have a long list of patients, you're trying to schedule a lot of procedures, that's when mistakes can happen. So that creates a concern for me when we have the potential for just more human error, because we're trying to do more maybe than we can. So the advice there is, after COVID, slow down, double down, right? Do it right. The other aspect of that pandemic deferral of treatment is, my friends in the oncology sector are concerned that we're probably going to see an uptick in cancers and some other outcomes, just because a lot of diagnostic work and a lot of checking in didn't get done, in addition to the treatments. Remains to be seen. We keep our fingers crossed. Hope we don't see it, but 40% of medical care being skipped is a pretty scary number for a year.
Well, Sam, I really appreciate you joining and sharing your insights. It's really fun for me. It's invaluable, frankly. And it is really fascinating that I learned something from my partners on an almost daily basis. And you are certainly one that teaches me things We are in a firm who is so deep into healthcare and our service to healthcare clients. And the work that we do for the healthcare industry goes far beyond those who are the traditional regulatory and transactional healthcare attorneys like myself. And it extends to so many other groups in the firm. And you and Diane Flannery and the rest of your team in the consumer and products liability group, the work you do in the industry is just, it's invaluable. And it helps our investor clients get a sense of what's going on in the marketplace, what to expect, kind of how to understand what's coming down the pipe. So appreciate you joining us today for Healthcare Headlines, and we will surely have you back soon.
Thank you for that. And it probably goes without saying, but it's a privilege for all of us to get to serve the healthcare clients that retain us and that ask us for advice, because at the end of all we do is, we hope, better patient outcomes.
Agreed. Thank you.
Thanks.